Hello and welcome. My name is Alan, and we are back with more of the United States Supreme Court, as we've been doing the judicial branch of the U.S. If you kept up with the channel, I do have two series, one on the judicial branch and the history it's gone through, and one on the executive branch and some of the history it's gone through. But today we are covering the important cases of the Morrison Waite Supreme Court while he was Chief Justice. So yeah. The Morrison Waite Supreme Court starts in 1874. If I can work the mouse, I really got to do something about that. I need you to work, mouse. Come on. Thank you. Okay. Chase. There he is. Morrison Waite. Chief Justice of the Supreme Court. March the 4th, 1874, and his term ending upon death on March the 23rd, 1888. So yeah, a little over 14 years. So with that said, let's look at some of these cases. We have a major case. It is Minor versus Happersett, 1875, so a year into term. March the 29th, 1875, Supreme Court unanimously upheld a previous decision that stated that the 14th Amendment did not apply to women. Virginia Minor was considered a citizen of the United States, but because she was a woman, she was not permitted to vote. So remember, 14th Amendment provided African Americans the right to vote. And of course, 1875, you're looking 10 years after the end of the Civil War. So there's still a lot of funny business going on. We're still struggling through Reconstruction, and of course there's a lot of BS going on with how things are being done. And this is one of them. Even though African Americans now had the right to vote, she was a female African American, and thus she was not permitted to vote. And of course, remember, women overall had yet the granted right to vote. They would attain later, 1920, I think it was around. So we were still 45 years away. United States versus Cruikshank, 1876. On April the 13th, 1873, 3 white men in Louisiana allegedly took part in the murders of approximately 100 black freedmen in an event referred to as the Colfax Massacre. The men were indicted and charged under the Enforcement Act of 1870. On appeal, the U.S. Supreme Court found the indictment to be faulty and ruled in favor of the three men. So again, a lot of BS going on. Even though we're supposed to be under Reconstruction when things are supposed to be better, you know, trying to equalize the rights of everyone. But no, we've got this BS going on. Wow. Let's go ahead and look this information up here. Pull this window down. Enforcement Act of 1870. Ba, 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 ba. And the Colfax Massacre. We'll bring, oh, right there, and right there. Now, Enforcement Act of 1870, the act to enforce the right of citizens of the United States to vote in several states of the Union and for other purposes. It was also called the Civil Rights Act of 1870, the Enforcement Act, the first Ku Klux Klan Act, and the Force Act. So yeah, seems to have passed the House and the Senate pretty unanimously. There was a little opposition, but very little. Signed into law by President Grant, May the 31st, 1870. And the U.S. versus Cruikshank would be one of the major cases dealing with it. The Enforcement Act of 1870, also known as the Civil Rights Act of 1870, or the first Ku Klux Klan Act or Force Act, is a U.S. federal law that empowers President to enforce the first section of the 15th Amendment throughout the United States. The act was the first of three enforcement acts passed by the U.S. Congress in 1870, 1871 during the Reconstruction era to combat voting rights of African Americans from state officials or violent groups like the KKK. So yeah, African Americans being newly freed try to enact their right to vote. And of course you have groups that are violent like the KKK, you know, which is fairly new at this point, attacking African Americans trying to vote. But you also have state officials having police and other groups push back on African Americans, saying, no, they're not allowed to vote. So, yeah. Now, the other part of it, the Colfax Massacre. Mm, they've got a plaque here remembering the events. On this side occurred the Colfax Massacre or Colfax Riot, in which 3 white men and 150 Negroes were slain. This event on April the 13th, 1873, marked the end of carpetbag misrule in the South. The Colfax Massacre occurred on Easter Sunday, April the 13th, 1873, in Colfax, Louisiana, the parish seat of Grant Parish. An estimated 62 to 153 black men were murdered while surrendering to a mob of former Confederate soldiers and members of the KKK. 3 white men also died during the confrontation. After the contested 1872 election for governor of Louisiana and local offices, a group of white men armed with rifles and a small cannon overpowered black freedmen and state militia occupying the Grant Parish Courthouse in Colfax. Most of the freedmen were killed after surrendering, and nearly another 50 were killed later that night after being held as prisoners for several hours. Estimates of the number of dead have varied over the years, ranging from 62 to 153. 3 white people also died, but the number of black victims was difficult to determine because many bodies were thrown into the Red River or removed for burial, probably at mass graves. Historian Eric Foner describes the massacre as the worst instance of racial violence during Reconstruction. And remember, that took place from the end of the Civil War to 1877. In Louisiana, it had the most fatalities of any of the numerous violent events occurring after the disputed gubernatorial contest in 1872 between Republicans and Democrats. Foner wrote, every election in Louisiana between 1868 and 1876, an 8-year period, was marked by rampant violence and pervasive fraud. Although the fusionist-dominated state returning board, which ruled on vote validity, initially declared John McEnery and his Democratic slate the winners, the board eventually divided, with a faction declaring Republican William P. Kellogg the victor. Republican judge in New Orleans ruled that the Republican majority legislature be seated. Remember, at this time, they were completely different parties. Republicans were actually the good party, and Democrats were the party of racism and discrimination and all that. Now, of course, there was the great political shift over time when you're in the 1900s, but yeah. At this point, they're on the opposite ends of what you now think of them as. But anyway, yeah, that's those two events. Let's continue on with the cases here. ruling on the Enforcement Act of 1876. Election officials Hiram Reese and Matthew Fauci refused to allow black man William Garner to vote, claiming that he owed money in taxes. Garner had attempted to pay his taxes, however, the tax collector would not accept the money. Garner was given a legal document stating that he tried to pay his taxes. Reese and Fauci refused to accept the document. The two were charged in accordance with the Enforcement Act of 1870. On appeal to the Circuit Court of the U.S. for the District of Kentucky, the indictment was overturned. The Supreme Court decided on March the 27th, 1876, that the act did not have the appropriate language to qualify for enforcement under the 15th Amendment. So even when these laws are passed, at this point in history, there's still groups are doing end-arounds and BS of all kinds. But yeah, Reese, I think it's Reese versus the United States or something, what the actual case is called. But yeah, remember, the U.S. versus Cruikshank is one, and the U.S. versus Reese. That's just what we just read. So yeah, those two cases are huge when it came to the Enforcement Act and how it was treated. So yeah. Let's see. 13th was abolition of slavery. 14th was I think was the right to vote. I'm not sure what the 15th always... There was like 3 in a row that dealt with after the ending of slavery. Next, we have a case that deals with saying polygamy is not legal from 1879. George Reynolds was a member of the Mormon Church and secretary to church leader Brigham Young. He challenged the state of Utah's ban on polygamy. Each court reviewing the case found that polygamy was illegal and subject to penalty. The Supreme Court unanimously affirmed the previous rulings, writing that the decision did not prohibit the freedom of religion, only the criminal activity of polygamy. So yeah, early in the Mormon Church and religion's history, they believed in polygamy as a right granted by God. But Utah was like, no. And Utah, of course, is where the Mormons were. They had traveled with Joseph Smith and Brigham Young from, what was it, St. Louis? They went westward and ended in Utah. I think by the time they got there, Joseph Smith was dead. And he was often considered the main founder of Mormonism. Brigham Young took over, and he's kind of really seen as integral to the history of Mormonism. But yeah, Utah said no. It went through the court systems higher up until it hit the Supreme Court. The Supreme Court's like, look, they judged right. Polygamy is not legal. You can still practice your religion, just not polygamy. And that's what they say. So, yeah. United States versus Harris, 1883. Sheriff Harris led by an armed mob to capture 4 black men imprisoned in a Tennessee jail. One of the imprisoned men was killed. The U.S. brought the charges against Harris and the mob, citing Section 2 of the Enforcement Act of 1871, prohibiting 2 or more people from trying to deprive others of equal protection of the law. And of course, the Supreme Court ruled that that act was unconstitutional. Again, these laws can be set in place, but often there are people who are like, I don't like that law, so I'm going to say it don't count. And that's what often happened. So yeah, it's a shameful part of American history, but it is history nonetheless that people should be aware of. You can't just hide history because it's not something you like. You have to understand it all. And that's what drives me crazy about some of these people. Like, well, I don't think it should be taught. I think it should be taught because so we can learn freaking lessons from it. Santa Clara County versus Southern Pacific Railroad, 1886. The Southern Pacific Railroad Company owned fences in the state of California. The state tried to tax the fences, but Southern Pacific argued that it could only tax the franchise, roadway, roadbed, rails, and rolling stock. Southern Pacific also argued that the state failed to properly assess its taxes by subtracting outstanding mortgages. The company refused to pay the fence tax and the difference in taxes assessed by the state. Santa Clara County sued the company, arguing that if it could tax the land that included the fences, then it could tax the increased value as a result of the fences. John Harlan delivered the unanimous opinion for the Supreme Court, holding that the state had wrongly imposed taxes and had not followed the proper procedures for reassessing the land value after the fences were added. Which is whatever. You have to understand, 1886, we're in the era of the Gilded Era, the first one, where you have all these big robber barons, Andrew Carnegie, John D. Rockefeller, James P. Morgan, James Vanderbilt. Those kind of names. Now we live in the modern era of the second Gilded Age, but this was the era of the first Gilded Age. Those individuals. So I'm not surprised the court would side with the company. It doesn't surprise me one bit. Yeah. Who they say read the opinion? John Harlan. So that would be, yeah, John Harlan. On the court from 1877 to 1911. I believe that's the right John Harlan. Yeah. Anyway, let's go on and look at some more cases through some other sites here. These are from Oye. I know it says Oyez, but it's pronounced Oye, like when you think about when they get a court to start. Oye, Oye! Please welcome the Honorable Justice. So on and so on. But, United States versus Reese. Remember, it was very hugely important in the Enforcement Act cases. January 1873, two election inspectors, Hiram Reese and Matthew Fauci, refused to allow William Garner, an African American, to vote in a municipal election in Lexington, Kentucky. Reese and Fauci claimed Garner had failed to pay a tax of $1.50. Remember, back in the day, that's quite a bit. I know a lot of people are probably cocking their head a bit. $1.50? No, remember, $1.50 is a lot in the 1870s. But Garner had attempted to pay the tax and was refused by a tax collector. The Enforcement Act of 1870, which defined penalties associated with violations of voting rights under the 15th Amendment, stipulated that if an official refused to permit a citizen to perform an action required for voting, the citizen could present an affidavit that would qualify him. Reese and Fauci refused to accept Garner's affidavit, saying he tried to pay. Reese and Fauci were charged with violating the Enforcement Act. On appeal, the Circuit Court of the U.S. for the District of Kentucky found relevant sections of the Enforcement Act too broad, exceeding the bounds of the 15th Amendment, and dismissed the indictments. So, yeah. Which is so petty and ridiculous. Next, we have Munn versus Illinois. This case was argued from January 15th, 1876 to January 18th, 1876. So over 3 days. And official decision was brought down on March the 1st, 1877. So a year later. Facts of the case. Illinois regulated grain, warehouse, and elevator rights by establishing maximum rates for their use. So, yeah. If you're going to have this business, this is the top you can charge. So, yeah. Conclusion. Well, they have a question. Did the state imposed rates deny the warehouse and elevator owners equal protection and due process under the 14th Amendment? No on both counts. Waite and the court took a broad view of the state's police power. He argued that the states may regulate the use of property when such regulation becomes necessary for the public good. Waite resurrected an ancient legal doctrine to support his view. When property is affected with a public interest, it ceases to be juris privati only. So yeah. But Munn versus Illinois. And they sided on the part of Illinois. Next, we have Reynolds versus the United States. Remember, this is the polygamy one we talked about earlier. It was argued November the 14th and 15th of 1878, and a decision handed down January 6th of 1879. The facts of the case: George Reynolds, member of the Church of Jesus Christ of Latter-day Saints, also known as the Mormon Church, was charged with bigamy under the Federal Moral Anti-Bigamy Act after marrying a woman while still married to his previous wife. Reynolds argued that the law was unconstitutional. He reasoned that his religion required him to marry multiple women, and the law therefore violated his First Amendment right to free exercise of religion. Is religious duty or belief a defense to a criminal charge? The conclusion was that the court upheld Reynolds' conviction and Congress's power to prohibit polygamy. The court held that while Congress could not outlaw a belief in the correctness of polygamy, it could outlaw the practice thereof. The majority reasoned that while marriage is a sacred obligation, it is nevertheless usually regulated by law in most civilized nations. Finally, the court held that people cannot avoid a law due to their religion. So yes, you can still follow your religion, but as long as you can follow it, then any law that goes on is fine. And of course you have many religious groups now being whiny and bitchy about it, but anyway. Strawder versus West Virginia. Argued October the 22nd, 1879, and had also been argued on October the 20th, 1879. Decision made on March the 1st, 1880. The facts of the case was that a West Virginia law declared that only whites may serve on juries. There was a question, though: does the state barring blacks from jury service violate the Equal Protection Clause of the 14th Amendment? The conclusion: yes. Justice Strong, writing for the majority, declared that to deny citizen participation in the administration of justice solely on racial grounds is practically a brand upon them, affixed by law, an assertion of their inferiority, and a stimulant to that race prejudice which is an impediment to securing to individuals of the race that equal justice which the law aims to secure to all others. So yeah. Next one we're going to look at is Stone versus Mississippi. It was a case argued March the 4th and 5th of 1880 and decided May the 10th of 1880. So they came to a decision on this one fairly quick. Facts of the case. In 1867, the Provisional State Legislature of Mississippi chartered the Mississippi Agricultural, Educational, and Manufacturing Aid Society. The society was chartered to run a lottery for the next 25 years. However, in 1868, a new constitution ratified by the people outlawed lotteries in the state. John Stone and others associated with the society were arrested in 1874 for running a lottery. The society claimed that they were protected by the provisions of their charter, while the state declared the subsequent enforcement legislation had repealed the grant. So, did Mississippi violate the contract clause by repealing the society's grant? A unanimous court found that the Mississippi classification of lotteries as outlawed acts was valid. The state legislature do not have the power to bind the decisions of the people and future legislatures. The court stated that no legislation had the authority to bargain away the public health and morals. I hate when they argue on morals. It's all BS. The court viewed the lottery as a vice that threatened the public health and morals. The contract protected the Constitution. In the Constitution are property rights, not governmental rights. Therefore, one can only obtain temporary suspension of the governmental rights. In this case, the right to outlaw actions in a charter which can be revoked by the will of the people. So, yeah, they had the right to perform an arrest because it is the will of the people that should be followed. Government shouldn't be able to overwrite said will. The civil rights cases. Yeah. This was argued March 29th, 1883 and decided October the 15th, 1883. The civil rights cases of 1875 affirmed the equality of all persons in the enjoyment of transportation facilities, in hotels and inns, and in theaters and places of public amusement. Though privately owned, these businesses were like public utilities, exercising public functions for the benefit of the public and thus subject to public regulation. In 5 separate cases, a black person was denied the same accommodations as a white person in violation of the 1875 Act. Does the Civil Rights Act of 1875 violate the 10th Amendment of the Constitution, which reserves all powers not granted to the national government, to the states, or to the people? Yeah. 10th Amendment more or less basically says, if it is an ability not expressly granted to the federal government, then it can be decided by the states or the people how to look upon things. The decision held that differentiating between state and private action, the majority ruled that the 14th Amendment did not permit the federal government to prohibit discriminatory behavior by private parties. Thus, Sections 1 and 2 of the Civil Rights Act of 1875 were unconstitutional because they exceeded Congress's authority under the 14th Amendment by purporting to regulate the conduct of private individuals. The court held that the act likewise exceeded Congress's authority under the 13th Amendment, which bars involuntary servitude and is restricted to prohibiting ownership of slaves, not other forms of discriminatory conduct. Justice Harlan advocated for a broader interpretation of the 13th and 14th Amendments. He pointed to the public function that these private places of accommodation serve. Harlan argued the line between state and private action is often blurred, such as how private railroads provide the government function of facilitating travel. He suggested that restrictions on the right to travel might violate the 13th Amendment prohibition against involuntary servitude, and argued that the privileges or immunities clause of the 14th Amendment may also be implicated. So yeah, they were a bit divided on how they viewed the case. Yeah, if I'm reading this right, I think it looks like it was an 8-1 decision, Harlan being the opposing voice. So, yeah. Again, we have that even though slavery is over, it's like there are still people who don't want to almost acknowledge that it exists, or that abolition happened, that slavery was ended. And it's like, come on, people. You know that's bullshit. Next case is Ex parte Crow Dog. August of 1881, a Native American named Kongishun Ka, Crow Dog in English, shot and killed another Native American on the Great Sioux Reservation in present-day South Dakota. The Sioux tribal government convicted Crow Dog and, applying traditional Sioux law, ordered him to pay restitution to the victim's family. The government of the Dakota Territory also charged Crow Dog with murder, and after being found guilty, Crow Dog was sentenced to death. Crow Dog appealed for a writ of habeas corpus and argued that the federal court lacked jurisdiction pointing to an 1834 act that specifically excluded crimes committed by one Native American on another from federal jurisdiction. The government argued that an 1868 treaty with the Sioux that required the tribe surrender criminals to the United States superseded the earlier statute. So yeah, government saying this treaty is newer than this one, meaning it counteracts and supersedes any decisions made in the prior treaty. Did the federal law grant the Dakota Territory Court jurisdiction over the murder for which Crow Dog was convicted? No. In a 9-0 decision authored by Justice Stanley Matthews, the court concluded that Congress had not granted federal courts jurisdiction over the murder of one Native American by another. The court interpreted the 1868 treaty stipulation that criminals be surrendered to the federal government in context, and given that the treaty was made between two parties, the party of whites and their allies and tribe of Indians, concluded the provision did not conflict with the repeal of the 1834 law. Justice Matthews' opinion goes on to note that while the law is clearly conflicted on the question because the 1834 law was never expressly repealed, there is no positive repugnancy between the provisions of the new laws and those of the old that would entail an implied repeal. So essentially, look, these are laws, a treaty we decided on between the whites and the natives, and it only applies if that native essentially kills another white. If they're doing violence to each other, that is their law, their issues to handle. Because under the 1834 law, while there was a newer treaty beyond it, it was never expressly repealed, and thus would hold much in case that, yeah, he was fine. Given that it was one Native American violence upon another Native American, not upon a white American citizen. Thus, they have no jurisdiction over it, even though there is a newer treaty that the Dakota Territory tried to argue superseded the 1834, and he's like, the court was like, look, no, it doesn't. Anyway, next one we want to look at Hurtado versus California. Argued January 22nd, 1884. Decided March 3rd, 1884. Another one of these really quickly decided. Facts of the case: the state of California tried and convicted Hurtado on an information for murder, And information is a written set of accusations made by a prosecutor. Hurtado maintained that California denied him an indictment by a grand jury, trial by one's peers. A grand jury indictment is based on majority vote of the grand jurors on presentation by the prosecutor. Does a state criminal proceeding based on an information rather than a grand jury indictment violate the 14th Amendment's due process clause? Conclusion was that no, this was not a violation of due process. Any legal proceeding that protects liberty and justice is due process. The majority opinion authored by Justice Matthews reasoned that the Constitution cannot be locked into static conceptions bound by time and place. The court also took the position that nothing in the Constitution is superfluous, since the Fifth Amendment contains both a guarantee of grand jury proceedings and a guarantee of due process. The latter cannot embrace the former. So, yeah. So, he was essentially indicted and convicted not by a grand jury, but through this information for murder, which was the written set of accusations made by a prosecutor. And of course, Hurtado tried to say, look, Fifth Amendment says trial by one's peers. I need to have my day in court surrounded by a jury to hear my case. And essentially the Supreme Court's like, no, you don't. While the Fifth Amendment does contain both a guarantee of a grand jury proceedings, it also provides a guarantee of due process, but the latter cannot embrace the former. So they do guarantee of due process cannot embrace the guarantee of a grand jury. So, yeah, you can still just get your due process without having being put in front of a grand jury, is essentially what it says. Ex parte Yarborough is our next case. Argued January 23rd and 24th of 1884 and decided March 3rd of 1884. It said that the Enforcement Act of 1870, which targeted the violence caused by the KKK in the post-Civil War South, prohibited the use of violence and or intimidation to prevent African Americans from voting. In 1883, 8 Georgia men, including Dilmus, James, Jasper, and Neil Yarborough, were charged under the Enforcement Act with intimidating Barry Saunders, an African American, to prevent him from voting in 1882 congressional election. The 8 were convicted and sentenced to 2 years in prison, Following their conviction, the 8 men filed petitions for writs of habeas corpus on the ground that Congress had no authority to pass the Enforcement Act. So yeah, we have 8 Georgia men charged under the Enforcement Act because supposedly they used intimidation and violence to try to keep Barry Saunders from voting in the 1882 congressional election. These 8 men were convicted and sentenced, but then filed writs of habeas corpus to challenge that. Did Congress have the authority to pass the Enforcement Act of 1870? Yes. In a unanimous opinion authored by Justice Samuel Freeman Miller, the court concluded that the federal government must have the power to protect the elections on which its existence depends from violence and corruption. After noting the implied powers of the Constitution are as much a part of the instrument as what is expressed, Justice Miller wrote that the necessary and proper clause of Article 1, Section 8, in conjunction with Article 1, Section 4, which provides that Congress may at any time make or alter regulations regarding the times, places, and manner of holding elections, granted Congress the necessary authority to pass the Enforcement Act. Additionally, the court an additional defense of Congress authority in the enforcement provision of the 15th Amendment. The court determined that the 15th Article of Amendment does substantially confer on the Negro the right to vote, and Congress has the power to protect and enforce that right. So yeah, essentially, look, Constitution says they have the right to pass such laws to protect the right of voting. That is what the Enforcement Act is. You don't like it, too bad. Yeah. Post-Civil War, post-slavery, got ridiculously ugly. Brown versus Houston. Argued April 3rd, 1884, and decided May the 4th, 1885. Louisiana man assessed an annual tax on goods which remained stored on flat boats prior to sale. Brown, a representative of a Pennsylvania coal mining company, refused to pay the tax on a load of coal which had been shipped to an agent in New Orleans. Did the Louisiana law violate the Constitution by opposing an improper restriction on interstate commerce? No. The court found that the Louisiana law did not violate the Constitution. Justice Bradley reasoned that since the law imposed a tax upon merchandise which had already arrived at its destination, merchandise which was effectively a commodity in the market of New Orleans, it was not offensive to the Commerce Clause. It was not a regulation on goods which were in a state of transit. Furthermore, the law did not discriminate against foreign producers because it applied to all goods within the state, not exempting products which had been made locally. So yeah. And we're almost done with all these cases. Here we're back with the Santa Clara County versus Southern Pacific Railroad Company. It was argued January 26th through 29th, 1886, and decided May the 10th, 1886. Facts of the case. The state of California taxed fences owned by the Southern Pacific Railway Company Southern Pacific asserted that the state constitution only allowed taxes on the franchise, roadway, roadbed, rails, and rolling stock. Southern Pacific also claimed that the state tax board did not properly subtract its outstanding mortgages from the value of its property. Southern Pacific refused to pay taxes on its fences, and the difference account for by subtracting outstanding mortgages. Santa Clara County brought action against it in state court. The county argued that since it could tax the land which situated the fences, it could also tax the additional value of the land added by the fences. Southern Pacific had the action moved to federal district court, which ruled that the state did not have jurisdiction to tax fences. The county appealed to the Supreme Court. Does the California Constitution allow the state to increase property taxes against railroad companies when the companies added additional value to the property by building fences? Did the state tax board wrongfully tax property without deducting for the outstanding mortgages against property owners? No and yes. Justice John Marshall Harlan delivered the opinion for a unanimous court. The state tax board tried to levy a single sum against the railroad company, which both wrongfully included the value of the fences and excluded a deduction of the outstanding mortgages. The state tax board increased taxes on the property based on the arbitrary measure of the value added by the fences. The state constitution required the state and its counties to separately assess the land and improvements thereon before increasing taxes. A state statute specified fences as a form of land improvement. The decision famously implied that equal protection laws provided by the 14th Amendment applied to corporations, but the opinion did not explicitly state this. So yeah, it was the corporations are people too before that case happened. That embarrassment of a case. United States versus Kagama. Argued March the 2nd, 1886. Decided May the 10th, 1886. In response to the court's ruling ex parte Crow Dog, in 1883, Congress passed a Major Crimes Act as part of the Indian Appropriations Act of 1885, which granted the federal courts jurisdiction over certain major crimes committed by one Native American against another. In June 1885, Kagama, a Native American, was tried for murder of Iyose, another Native American, on the Hoopa Valley Reservation in California. At trial, Kagama challenged the court's jurisdiction over the matter, arguing that the relevant section of the Indian Appropriations Act was unconstitutional. On appeal, Kagama received a division of opinion from the Circuit Court of the U.S. for the District of California. The question being, does the part of the Constitution grant Congress the power over the jurisdiction of crimes committed by one Native American against another? And it concluded that yes, in a unanimous opinion authored by the Justice Sam F. Miller. The court acknowledged the Constitution of the U.S. is almost silent in regard to the relations of the government, which was established by it to the numerous tribes of Indians within its borders. Nonetheless, the court reasoned that because the tribal governments owe all their powers to the statutes of the U.S., conferring on them the powers which they exercise and which are liable to be withdrawn, modified, or appealed at any time by Congress, the legislature could therefore control jurisdiction of crimes committed within reservations. Describing Native Americans as wards of the nation, the court concluded from the very weakness and helplessness so largely due to the course of dealing of the federal government with them and the treaties in which had been promised, there arises the duty of protection and with it the power. Saying, more or less reversing the ex parte Crow Dog decision. Saying, look, yeah, Congress has the right to do this, to make these laws. Finally, we have Mugler versus Kansas. Argued October the 11th, 1887, and decided December the 5th, 1887. A Kansas law prohibited the manufacture or sale of intoxicating liquor. Mugler was arrested for making and selling beer. The case was decided together with Kansas versus Zyobode. Does the Kansas law violate the Due Process Clause of the 14th Amendment? According to Harlan, the Kansas prohibition does not infringe on the 14th Amendment rights, though Mugler has an abstract right to make liquor for his own personal use. Such a right could be conditioned on its effect on others. Here, the state legislature may exercise its police powers. More or less, look, if you'd kept it to yourself, you'd probably been okay, but it's selling or just giving it away. You completely changed the situation in that case. So, yeah. But that will end our look at the Waite Court. The court under Chief Justice Morrison Waite. Yeah. And the next court, in the next episode, we will start with the Fuller Court, which is one of these longer term courts, if I remember right. I think it was like 20-some years. 21 years, 269 days. So almost 22 years. The Melville Fuller Court. think he served until death. Yep, 1910. So that means he would serve. He would be appointed by Grover Cleveland, but he would serve 1910. Let's see, McKinley, Teddy Roosevelt, William Howard Taft, I think, is the last president he serves under. So, yeah. Quite a few new justices because he was he was the Chief Justice for so long. William Howard Taft, yeah. Okay, so yeah. Next episode we do on the Supreme Court will be starting into the Melville Fuller Court. But that will end this episode. As always, educate thyself. Think, read, study, learn. Someone tells you something you have trouble believing, ask them to cite their sources. I'll be putting these links in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.